Good morning and welcome to one of our first junior webinars for 2023. I am Zachary Kell and today I'll be taking up some of your time on a deceptively simple yet quite technical problem for commercial lawyers, i.e. when does time start to accrue on a claim for services under a simple contract? In particular, where there are provisions for the time in which invoices should be paid. I will look at a case in which I appeared in December last year, consulting Concepts International Incorporated and Consumer Protection Association Saudi Arabia, a case that has caused enough of a stir to end up in the fourth volume of the 2023 weeklies, i.e. the one they only publish online. Subsequently, Mr. Jamie Cockfield will talk about the often contentious issue of whether pre-contractual documents are legally binding and enforceable. In particular, he will talk about a case led by Dov Orenstein of these chambers of Pretoria Energy Limited and Blankney Estates Limited, dealing with the important issue of heads of terms, which will be heard in due course by the Court of Appeal. Now, I'm going to do the technologically dangerous thing of trying to share my screen. There are three key issues for today's talk, namely the basic rules of limitation for contracts for services, how the case of CCI and CPA dealt with those principles, and key takeaways for drafting contracts of the future. And I'd also add how we approach litigation with these types of agreements. The Brooklyn poet Delmore Schwartz famously declared in 1937, "Time is the fire in which we burn." And the Limitation Act 1980 proves to be no exception. What do we mean when we talk about limitation? Professor Andrew McGee's leading textbook, Limitation Periods, now in its 8th edition, defines a limitation period as including any provision which specifies a time limit within which legal proceedings of a particular kind must be brought, or exceptionally, within which notice of a claim or dispute must be given to another party. It is, of course, that first part that we will be focused on today. The limitation of actions is entirely a matter of statute, as interpreted by the courts, and going as far back as the Court of King James I, with the Statute of Limitations 1623. Fast forward to today, and the key statute that we should all be familiar with is the Limitation Act 1980. For today's purposes, we will be looking at Section 5, which provides the time limit for actions founded on simple contract, stating, and I quote, "An action founded on simple contract shall not be brought after the expiration of 6 years from the date on which the cause of action accrued." The question for us then is, when does the cause of action for a claim under a contract of services actually accrue? Let's go back to the late 19th century and look at what is one of the fundamental cases in this area, Coburn and College. As with today's position, under Section 69 of the Solicitors Act 1974, under the previous Section 37 of the Solicitors Act 1843, a solicitor had to wait 1 month from delivery of their statute bill before bringing an action for recovery of their fees. Similarly, all actions of debt grounded upon lending or contract have to be commenced within 6 years per what was Section 3 of the 1623 Statute of Limitations that I referred to. A further complication that's novel to this time arose by virtue of another statute of limitations, one of the Acts of Queen Anne, which provided that if at the time of the debt or cause of action accruing, should the debtor have fallen or come beyond the seas, then time effectively pauses until after their return from beyond the seas. And we'll see in a moment why that's relevant to this case. With that in mind, the facts of Coburn were as follows. On the 30th of May, 1889, Mr. Coburn, the solicitor, had completed certain work for Mr. College. On 7th of June, Mr. College left England and went beyond the seas. On 12th of June, Mr. Coburn posted a letter containing his signed bill of costs in respect of the work done, addressed to Mr. College and sent to his last known address, being his father-in-law's home in Guernsey. Ultimately, this reached Mr. College, who at the time was residing in Australia, far beyond the seas, in 1891, so a couple of years later. Mr. College returns from his voyage in 1896, and on the 12th of June of 1896, Mr. Coburn finally commences his action. At first instance, it was held that Mr. Coburn could not avail himself of the Acts of Queen Anne because at that point the work had been completed when Mr. College was still within the jurisdiction, i.e. the 30th of May, 1889. On appeal, this was upheld, and the core principle in this case can be found in the judgment of Lord Esher, then Master of the Rolls, who explains at page 705 of his judgment, and I quote, "The question is when in such a case as this, the cause of action arises. The action is brought by the plaintiff in respect of work done by him as a solicitor. In the case of a person who is not a solicitor and who does work for another person at his request on the terms that he is to be paid for it, unless there is some special term of the agreement to the contrary, his right to payment arises as soon as the work is done, and thereupon he can at once bring his action." The argument for Mr. Coburn was run that because of section 37 of the Solicitors Act, there was some effect on when time should start to run as a result of the 1-month procedural bar. Lord Esher rejected this argument, explaining at page 706 of his judgment, "Similarly, I think section 37 deals not with the right of the solicitor, but with the procedure to enforce that right. It does not provide that no solicitor shall have any cause of action in respect of his costs or any right to be paid till expiration of a month from his delivering a signed bill of costs, but merely that he shall not commence or maintain any action for the recovery of fees, charges, or disbursements until then. It assumes that he has a right to be paid the fees, charges, and disbursements, but provides that he shall not bring an action to enforce that right until certain preliminary requirements have been satisfied. If the solicitor has any other mode of enforcing his right than by action, the section does not seem to interfere with it. For instance, if he has money of the client in his hands not entrusted to him for any specific purpose, there is nothing in the section to prevent his retaining the amount due to him out of that money." And now the section that I've just emphasised, if that be the true construction of the section, it does not touch the cause of action, but only the remedy for enforcing it. The definition of cause of action which I gave in Reed and Brown has been cited. I there said that it is, quote, "every fact which it would be necessary for the plaintiff to prove if traversed in order to support his right to the judgment of the court." The other judgments of Lord Justices Lopez and Chitty concur with the Master of the Rolls, adding the following glosses. First, Lord Justice Lopez considered the position if Mr. Coburn's argument was correct about time being affected by the 1-month bar on issuing a claim on a statute bill, and set out an extreme example where, quote, "the solicitor may abstain from delivering his bill for 20 years, and then at the end of that time, he may deliver it and sue after the expiration of a month from its delivery. It seems to me that this would be a very anomalous and inconvenient result." Second, Lord Justice Chitty examined the difference between a right of action and a cause of action, stating, quote, "it is in no way affects the cause of action, or it in no way affects the cause of action, forgive me, which is money payable for work done, but only postpones the right of action upon it for at least 1 month from delivery of the bill." In answer to the submission that the solicitor would have to deliver a bill within a reasonable time, Lord Justice Chitty rejected the same, explaining, quote, "that suggestion is contrary to the whole scope of the statutes of limitation, which is that instead of it being left in case of delay to the court to say what is unreasonable delay, as occurred sometimes in cases of the Court of Chancery, a fixed period should be laid down by enactment." Later, I will return to how the Court of Appeal recently in CCI treated all of these principles in Coburn, and they're all very important to bear in mind for the remainder of this talk. So I won't go into any in-depth analysis just yet. First, I want to skip a century and a little bit forward and look at another important decision, which is the Court of Appeals in Henry Boot Construction Limited and Alston Combined Cycles Limited. In this case, the claimant, a contractor, was employed by the defendant for the main civil works for the construction of a power station. The standard form contract provided that within 28 days of the date of delivery to the engineer of the claimant's monthly statement, the engineer would give a certificate and the defendant would pay to the claimant the sum certified. In an arbitration, it was held that the claimant's claim was statute barred because time began to run from the date the works had been completed and not the date of certification. On appeal, the arbitrator's decision was overturned. The Court of Appeal held that as a matter of construction, the standard term of certification was a condition precedent to the claimant's entitlement to payment, and therefore the claim was not statute barred. I've not set out the particular certification provisions, which are clause 60 of the relevant contract in Henry Boot. They're rather extensive. However, it would be worth going away after this talk and having a brief look. It's summarised by Lord Justice Dyson, as he then was, at paragraph 18 of the judgment. It's quite extensive, as I say, and it provides lots of steps that need to be followed before the entitlement to payment arises. In his judgment, Lord Justice Dyson examines the argument that is offered by the defendant as to why this claim should be dismissed and reiterates the Coburn principle at paras 19 and 20 as follows. Counsel for the defendant submits that Boot's cause of action accrues on the doing of the work, not necessarily brick by brick, but periodically, which for the purposes of the Limitation Act 1980, he says he means day by day, and in any event, at the end of each period for which Boot is first entitled to submit a statement of the value claimed. The engineer's valuations and certificates under clause 62(4) are irrelevant to the accrual of the cause of action. They are no more than evidence of the engineer's opinion of what is due to Boot. The entitlement to payment exists independently of the exercise of that machinery by the engineer, because in this contract, the engineer does not create rights for the contractor, rather he recognises and assesses or determines what Boot's rights are at any given time. An early authority on which counsel for the defendant relies is Coburn and College. This establishes the proposition that where A does work for B at B's request on terms that A is entitled to be paid for it, his right to be paid for it, i.e. his cause of action, arises as soon as the work is done, unless there is some special term of the agreement to the contrary. In my view, this decision is not sufficient to vindicate counsel for the defendant's argument for two reasons. First, it begs the question of what is the work for this purpose? Is it the whole of the work which is the subject of the contract, or certain separately identified parts of the work? Secondly, the question arises whether, as counsel for the claimant submits to be the case, clause 60 is a special term of the agreement to the contrary. And ultimately, the Court of Appeal decides that it is, in fact, a special term. In the Henry Boot judgment, you can see where the issue and the fault lines lie between the parties, and especially for the defendant from those passages that I've just cited. It's not just a straightforward solicitor's retainer, as in Coburn, where the right to be paid can be found quite clearly on its face. Therefore, a practical tip when faced with a contract for services that might well lead to a statute-barred claim is to first of all map out the contractual provisions that lead to a proposed claimant or your client's right to payment. If there is a straight line from the service being provided to the obligation to pay, then you're more likely to be in Coburn territory. However, if there are a number of hurdles to get to payment, certification provisions, conditions precedent, then you may well find yourself in Henry Boot territory, whereby the time in which the cause of action accrues much later than you first might have thought, if it has accrued at all. Now, there are many different cases, like Henry Boot, that I could talk about in the lead up to CCI. Indeed, the joint authorities bundle in the CCI appeal had at least 26 cases in it dealing with various aspects of these issues. What I will do is briefly set out two more key authorities and then list a couple of more for the audience and post-webinar research to be conducted at their leisure. First, Legal Services Commission and Henthorne. In this case, the LSC brought a claim against a voluntarily disbarred barrister for alleged overpayments of legal aid. The court held that claims were not statute barred because time started to run once an assessment was completed under Regulation 100 sub 8 of the Civil Legal Aid General Regulations 1989, rather than from the date that the work under the certificate was completed. Importantly, Lord Newburger, who at the time was the Master of the Rolls, stated at paragraph 31 of his judgment, quote, "Save where it is the essence of the arrangement between the parties that a sum is not payable until demand, e.g. a loan expressly or impliedly repayable on demand." And I should say there are different provisions for loans in the Limitation Act that need to be borne in mind when you're reading that passage. It appears to me that clear words would normally be required, clear words, before a contract should be held to give a potential or actual creditor complete control over when the time starts running against him, as it is such an unlikely arrangement for an actual or potential debtor to have agreed. So emphasising that point about clear words. We'll come back shortly as to where that passage ends up in the judgment in CCI. Second, an appeal in the High Court, which the Court of Appeal approved in CCI, is ICE Architects Limited and Empowering People Inspiring Communities, 2018, before Mrs. Justice Lambert. In that case, the claimant was a firm of architects that agreed to provide design services for a scheme being developed by the defendant. The defendant had written to the claimant stating that the claimant would invoice the defendant on a monthly basis, and the defendant would endeavour to make payment within 30 days of receipt of the invoice. Mrs. Justice Lambert rejected the claimant's argument that this was an agreement that the claimant's entitlement to payment did not arise until after 30 days had passed from the issuance of the invoice, and held that the claim was statute barred. Finally, two other relatively recent cases to consider, which are there on the slide, are Hurst and Dunbar before Mr. Justice Eyre, and Horlick and Cavaco before Mr. Justice Friedman. Now, for one of the most recent of all the judgments, CCI and CPA, the reason we've all come together to talk about this. The facts were as follows. Consulting Concepts International Incorporated, the claimant, is a New York corporation which provided services to the Consumer Protection Association, the defendant, a civil organisation incorporated under the laws of the Kingdom of Saudi Arabia. The parties agreed to collaborate to develop and implement strategies, programmes and public policies to address the root causes of asthma, its prevalent misdiagnosis, treatment compliance and paediatric continuing education in Saudi Arabia, as well as to promote proven therapeutic protocols to enhance and improve the life of Saudi Arabia's youth, as set out in the agreement between the parties. And per the terms of that agreement, the parties expressly agreed to submit to this jurisdiction. The June 2013 agreement envisaged that CCI would be remunerated for this work, but it made no provision for the rate of remuneration. The key provision for the purposes of this case and what we're discussing is found under the heading Responsibilities of Consumer Protection Association, and it's on the slide. It says, all invoices submitted by CCI will be paid within 90 days if funds of stakeholders are available by submission of said invoice by Consumer Protection Association to a bank account designated by CCI. At all material times, CPA had funds of stakeholders available to make payments. So whether or not that's a condition precedent doesn't really have much bearing on the outcome of the case. There was also an undertaking provided by CPA to CCI to transfer 161.5 million Saudi riyals to the account of the director of CCI by the 31st of December 2013. And that undertaking was received on or around the 2nd of October 2013. I'm not going to trouble us too much with that. The claim was issued on the 27th of December 2019 in the Commercial Court. And Mr. Justice Jacobs granted the defendant's application for strikeout summary judgment on the basis that the action was time-barred. However, Mr. Justice Jacobs did grant the claimant permission to appeal to the Court of Appeal. One of the difficulties that he raised in his first instance judgment at para 63 was this, quote, had Cockfield been the only authority relied upon in the present context, I would have been inclined to accept CCI's arguments that there was no cause of action until the expiry of 90 days. However, matters have developed in the years since Cockfield. It's worth asking, therefore, whether the question of what is a special term that we've touched on in Cockfield and College has been definitively answered by Cockfield, or has it been significantly changed or developed across later case law such as Henry Boot, Henthorne and ICE, and that's one of the key things that was put before, one of the key matters and issues put before the Court of Appeal in this case. Lady Justice Andrews, delivering the judgment of the Court of Appeal, examined the Cockburn principle, and in particular the question of when a cause of action accrues, analysing Lord Esher's judgment that I quoted earlier in this talk as follows at paragraph 27. Her Ladyship says, Lord Esher confirmed that a cause of action is complete when the claimant can assert all the facts which it would be necessary for him to prove in order to support his right to judgment. When the work was finished, the solicitor could have brought his action claiming money payable for work done at the request of the defendant. And unless the defendant set up something to defeat the claim, the action would have been maintainable. The defendant might plead that no bill of costs had been delivered, but that would only be by way of answer to a case which constituted a good cause of action. The Master of the Rolls was there drawing a distinction between circumstances in which a defendant can strike out the claim as disclosing no cause of action and circumstances in which he can raise a substantive defence to the claim. The fact that the debtor has not yet received an invoice seeking payment or other notification that the work had been done falls into the latter category. In rejecting the claimant's appeal, the Court of Appeal gives a pretty definitive answer as to what they view as a special term, certainly in this context, and approving Mr. Justice Jacobs' judgment at first instance in the Court of Appeal's judgment at 35 as follows. Quote, the judge rightly identified in para 58.4 that the critical distinction is between terms which are conditions precedent to the right to payment arising and terms which impose conditions for the bringing of proceedings, which are concerned with limiting the creditor's right to bring an action to enforce an entitlement to payment. The latter are procedural obstacles which do not prevent the running of time unless they are covered by one of the exceptions in the Limitation Act 1980. The fact that, as is commonplace, the debtor is afforded a certain amount of time to pay does not postpone the accrual of the cause of action, though it may afford him a defence to the claim, which is brought before the expiry of the period of credit. Lady Justice Andrews went on to approve that dictum of Lord Newburger that I referred to in Henthorne, that there would need to be clear words for a special term to arise, and this is at 36 of her judgment. Lady Justice Andrews adds at 37 of her judgment, quote, Lord Newburger went on to point out that it is always a matter of construction in the individual case, whether there is a difference between the date on which the claim arose and the date from which it was actionable. Lady Justice Andrews also went on to approve Mrs. Justice Lambert's decision in ICE, agreeing with Mr. Justice Jacobs at first instance that it was powerful authority in the present context and calling it strikingly familiar to the present case. What then can we take from all this and from this judgment that we can take into practice? The accrual of a period of limitation in a contract for services has nothing to do per se with the time in which the payment is due or falls due, for example, under an invoice. Even if there is a bar in place procedurally, such as under the Solicitors Act, and still in place under Section 69, the 1 month procedural bar under statute, or contractually, such as the 30 days period in ICE Architect and 90 days in CCI for an invoicing clause, that does not mean that time will run from the first point at which the bar is lifted. The only way to ensure that time is paused is to have either a complex set of certification provisions or conditions precedent that prevent the cause of action accruing, such as in Henry Boot, or to have very clear wording that indicates the parties have agreed to effect the accrual of the cause of action / the period of limitation. However, it will remain to be seen if it's enough to state that a 90-day invoicing provision, just to take the period in CCI, expressly stated as displacing the start date under Section 5 of the 1980 Act, will be clear enough on the construction of the agreement, bearing in mind the point Lord Newberger makes in Henthorne, that at the end of the day, it's the construction that matters, would be enough. In theory, it should be, but there is not yet any reported case on all fours with this hypothetical situation. To conclude, though, this morning we've examined the classic principles underpinning the law of limitation in a contract for services, so Section 5 of the 1980 Act, Coburn, Henry Boot, etc. How the Court of Appeal in CCI and CPA have applied these principles, and finally, some practical takeaways to assist with our cases going forwards. Thank you for listening, and I will now pass over to Jamie.
Thank you, Zach. Let me just share my slides. I'm Jamie Cockfield, and I'm going to talk today about when pre-contractual negotiations can become legally binding. The title of my talk is Heads of Terms and Subject to Contract, 8 Key Principles on when pre-contractual negotiations are legally binding. In commercial negotiations, it's common for parties to obviously exchange various documents in the lead up to the formation of a contract, or if no formal agreement is reached, as part of negotiations which ultimately fail or are abandoned for some reasons. These documents are often termed, labelled or headed heads of terms, letters of intent, heads of agreement, intention to proceed. There are a wide variety of different phrases used. They may also have the phrase subject to contract or other similar wording within them. And that similar wording is often seen as an equivalent to subject to contract. And they're commonly entered into and signed by both parties. This is obviously a particularly fraught area of law, which gives rise to frequent disputes over whether such documents have become legally binding. And over the course of this talk, I'll outline the legal principles, and I hope this is of some practical use to solicitors, which should be considered when assessing whether pre-contractual documents are legally binding and enforceable. Obviously, recognizing and understanding these legal principles will help, or should help, practitioners avoid unintentionally creating legally binding agreements when drafting what they intend to be pre-contractual documents. The first case I would consult if faced with this kind of issue is the Supreme Court case of RTS and Mulcahy from 2010. However, there are a number of later decisions which provide guidance on the legal principles relevant to this type of case. And one of the recent cases, the High Court decision on which Dove Orenstein from Radcliffe Chambers was successful for the defendant, is Pretoria Energy Company and Blankney Estates before Deputy Judge Joanne Wicks, KC. As Zach mentioned in the introduction, the case is subject to an appeal and will be heard in the Court of Appeal later this year. But it's my understanding that the key principles regarding non-contractual documents and the legal principles surrounding this are not subject to the appeal and were not disputed in the first instance decision. It is, of course, worth keeping an eye out for this judgment in any event. The key principles, as I said, were not in dispute in Pretoria Energy, and I've outlined 8 of these, which should be considered when approaching cases like this. I address these 8 principles in no particular order and cover some of them only very briefly for reasons of brevity. The first is this, and I would suggest, along with the 8th and final principle, this is perhaps the most significant one. Whether there is a binding contract depends not on the subjective state of mind of the parties, but on a consideration what was communicated between them by words or conduct. This is from the case of RTS and Mulcahy, and in that case, the parties had negotiated contract terms subject to contract, but work had commenced before the terms had been finalised, and there was held to be a binding agreement in this case. The first thing that a case like this demonstrates is the peril of beginning work without a precise basis on which it is to be done. And the key principle, as I said in conjunction with the 8th, is at paragraph 45, and it's on the slide in front of you. Whether there is a binding contract between the parties depends not on their subjective state of mind, but on a consideration of what was communicated between them by words or conduct, and whether that leads objectively to a conclusion that they intended to create legal relations and had agreed upon all of the terms which they regarded or the law requires as essential for the formation of legally binding relations. Even if certain terms of economic or other significance to the parties have not been finalised, an objective appraisal of their words and conduct may lead to the conclusion that they did not intend agreement of such terms to be a precondition to a concluded and legally binding agreement. Now, often in cases such as this, the parties will seek legal advice and state very honestly that they did believe or did not believe that a legally binding agreement had or had not been made. But this, of course, is not the test that the court will apply when considering these cases. And perhaps the sort of strength of feeling of parties of how they feel and how they thought at the time and their subjective state of mind is one of the reasons why there are a number of Court of Appeal decisions on this point and a couple of Supreme Court decisions. Of course, the court is going to be concerned with this objective assessment of words and conduct, or rather an assessment of words and conduct, and whether that objectively leads to a conclusion that they intended to create legal relations. The second related principle is that whilst the issues of contractual certainty and intention, which were referred to in the passage I quoted from RTS above, whilst they are distinct, one issue may inform the other. Lord Clark's passage, as I said, mentions both of these. They are distinct points, and in the case of Joanne Properties, Lord Justice Lewison stated that, in my judgment, the judge seriously undervalued the force of the subject to contract label on the legal effect of negotiations. He also failed to separate the two distinct questions: A, whether the parties intended to enter into a legally binding arrangement at all, and B, whether the agreed terms were sufficiently complete to amount to an enforceable contract. Almost all the points that he mentioned went to that second question rather than the first. So that's the point of the two distinct questions. Both Pretoria Energy and the case of McKinns and Gross go further and indicate that although these are distinct questions, one may inform the other. The more vague and uncertain, for example, an agreement is, the less likely it is that the parties intended it to be legally binding. The third key principle, it is necessary to look at the whole course of dealing between the parties to decide whether a contract has been formed. And the authority for this is on the slide. It's Global Asset Capital, an A-bar block 2017 Court of Appeal decision. And again, this is in the principles in the Pretoria Energy and Blankney case. The whole course of dealing issue gives rise to an important point, which can often be mixed up. It's well established that in deciding whether a contract has been made during the course of negotiations, the court will look to the whole course of dealing during those negotiations. And as Lord Cairns said in the 19th century case of Hussey and Horne Payne, you must not at one particular time draw a line and say, we will look at the letters up to this point and find in them a contract or not, but we will look at nothing beyond. In order to fairly estimate what was arranged and agreed, if anything was agreed between the parties, you must look at the whole of that which took place and passed between them. Then at paragraph 27 of her judgment in Pretoria Energy, Deputy Judge Joanne Wicks said, events which occur after the making of the alleged contract may be relevant to understanding whether, objectively, the parties intended their dealings to be contractually binding, even though they would be irrelevant to the question of how any contract so made should be interpreted. And this is the tricky point that can sometimes get mixed up. When looking at the whole course of dealing, events which occur after the making of alleged contract are irrelevant to the question of contractual interpretation. However, events or conduct which occur after the making of the alleged agreement are relevant to the question of whether a contract has been formed at all. And that third key point is a key principle, is very significant. The fourth one, it is for the parties to choose which terms they regard as essential for the formation of a contract. I'll go through this rather quickly. For further guidance on this, I direct you to the case of Barbie Devon Eurocom, which is on your slide at paragraph 32, and that's the fourth principle. It's for the parties to choose which terms they regard as essential. The fifth key principle is that it's the onus of demonstrating that there is not the necessary intention lies on the party who asserts it. And this onus is a heavy one. And the quote is from an earlier case, and there are earlier cases than this, but it's on the slide in front of you from Edwards and Skyways. In the present case, the subject matter of the agreement is business relations, not social or domestic matters. There was a meeting of minds, an intention to agree. There was, admittedly, consideration for the company's promise. I accept the propositions of counsel for the plaintiff that in that case, this nature, or in a case of this nature, the onus is on the party who asserts that no legal effect was intended, and the onus is a heavy one. The sixth key principle is that the courts are reluctant to find an agreement is too vague to be enforced, and the court may also imply terms to fill the gap. On the first point, the parties intend to be contractually bound. The courts are reluctant to find agreement is too vague to be enforced, is from paragraph 18 of Wells and Devani, the 2019 Supreme Court judgment. It may be the case, and I quote from that paragraph, it may be the case that the words and conduct relied upon are so vague and lacking in specificity that the court is unable to identify the terms on which the parties have reached agreement, or to attribute to the parties any contractual intention. But the courts are reluctant to find an agreement is too vague or uncertain to be enforced, where it is found that the parties had the intention of being contractually bound and have acted on their agreement. Furthermore, the important point that, particularly in the commercial context, the court may imply terms to fill any gaps of this uncertainty. And the important authority in that case, on this point, is Mammoth Oil, Jet Oil, Greek Petroleum Company, and Octa Crude Oil. And I quote from that, where no contract exists, the absence of agreement on essential terms of the agreement may prevent any contract coming into existence, again on the ground of uncertainty. However, particularly in commercial dealings between parties who are familiar with the trade in question, and particularly where the parties have acted in the belief that they had a binding contract, the courts are willing to imply terms where that is possible to enable the contract to be carried out. The seventh important principle, sorry, I think I skipped a slide. I think I skipped the sixth slide there, but the seventh important principle is this. Business people often record important agreements in a very crude and summary fashion. And this comes from an old case from the 1930s, Hillas & Co. v. Arcos. Businessmen often record, and of course in the 1930s it was most likely businessmen, often record the most important agreements in crude and summary fashion. Modes of expression sufficient and clear to them in the course of their business may appear to those unfamiliar with the business far from complete or precise. It is accordingly the duty of the court to construe such documents fairly and broadly, without being too astute or subtle in finding defects. But on the contrary, the court should seek to apply the old maxim of English law, and I won't try you with my Latin, but it broadly translates as words are to be understood such that the subject matter may be more effective than wasted. And that is Hillas and Arcos from 1932. So to move on to the eighth principle, which, as I suggested, along with the first principle, is perhaps the most significant when considering these types of cases. The principle is this, or rather than being one principle, it's sort of two closely connected principles. That is, it is not essential that parties expressly negative contractual intention, firstly, and secondly, it is nor is it always conclusive when they do. The first of these principles, that to expressly negative contractual intention is not always essential, can be found in a number of authorities and is said at paragraph 42 of the Court of Appeal case of Whitehead Man Limited and Chevenix Consulting. And I quote from that Court of Appeal case: "The more complicated the subject matter, the more likely the parties are to want to enshrine their contract in some written document to be prepared by their solicitors. This enables them to review all the terms before being committed to any of them. The commonest way of achieving this ability is to stipulate that the negotiations are subject to contract. In such a case, there is no binding contract until the formal written contract has been duly executed." See the Chinook and Marchioness of Ely. But it is not essential that there should have been an express stipulation that negotiations are subject to contract. On these two closely related principles, perhaps the best authority to look at is another Court of Appeal case, and that is Joanne Properties and Moneything Capital from 2020. In Joanne Properties, the issue on appeal was whether the parties had entered into a binding contract of compromise in written communications between their respective solicitors. In the first instance decision, Mr. Anthony Metzer Casey held that they had entered into a binding contract. This was overturned in the Court of Appeal, which found the first instance judge had seriously undervalued the force of the subject to contract label on the legal effect of negotiations between solicitors. The authorities on this oft-used term in English contracts, subject contract, are of course legion and go back a long way, and they're reviewed at paragraphs 12 to 24 of Lord Justice Lewison's judgment in the field case of Joanne Properties. I'll run through some of those briefly. They are very helpful in understanding this legal principle or how to interpret subject contract. In Tiverton Estates Limited and Warewell from 1975, Lord Denning said, and I quote, "It is everyday practice for a solicitor who is instructed in a sale of land to start the correspondence with a letter subject to contract, setting out the terms or enclosing a draft. The reason is that for over 100 years, the courts have held that the effects of the words subject to contract is that the matter remains in negotiation until a formal contract is executed. Similarly, in the case of, again, a Court of Appeal case, Secretary of State for Transport and Christos from 2003, it was said at paragraph 34, as everybody knows, that expression, when used in relation to sale of land, means that although the parties have reached an agreement, no legally binding contract comes into existence until the exchange of formal written contracts takes place. Moreover, in the course of their judgment, both Lord Denning and Lord Justice Templeman approved the position as it was formulated by Brightman J. in Tevenant and Norman Breck Builders from 1972, and that is that parties could get rid of the qualification of subject to contract only if they both expressly agreed that it should be expunged, or, and this is significant, if such an agreement was to be necessarily implied. RTS and Mulcry obviously did involve a subject to contract type clause, and Supreme Court held on the facts of RTS that the clause had been waived, not least because the contract had been partly performed. On the general approach applicable, Lord Clark said at paragraph 47, "We agree that in a case where a contract is being negotiated subject to contract and work begins before the formal contract is executed, it cannot be said that there will always or even usually be a contract on the terms that were agreed subject to contract. That would be too simplistic and dogmatic an approach. The court should not impose binding contracts on the parties which they have not reached. All will depend on the circumstances." And of course, this principle, as many authorities show, is not only applied to the sale of land. RTS Mulcry is one example. And another good example is the context of deciding when an arbitration claim under shipbuilding contract had been settled in the case of Goodwood Investments Holding and ThyssenKrupp from 2018 in the High Court. There are also a number of other helpful authorities on the lifting of subject to contract by implication. And a helpful one is Jaya House Capital and Bella from 2009 in the High Court. I've listed a few cases there on the PowerPoint slide. So to conclude on that point on subject to contract, it's helpful to go to Joanne Properties, and the key principle is set out at paragraph 34 in Lord Justice Lewison's conclusion. And it is that subject to contract meant, in that case, firstly, that neither party intended to be bound in either law or equity, and unless and until a formal contract was made. That's A. And B, each party reserved the right to withdraw until such time as a binding contract was made. Once negotiations were begun, subject to contract, that condition would be carried through the negotiations, and in this case there had been no express agreement that the subject to contract qualification should be lifted or expunged, and there was no reason to imply such a position. So that's to look into this further, I would direct you to that case of Joanne Properties and Lord Justice Lewison's judgment. To move on from the phrase subject to contract, still within that important eighth principle, there are some recent cases on heads of terms. And as I said, the label heads of terms or other similar labels on a document is not conclusive, or neither is it absolutely necessary to negative contractual intention. A document which has heads of terms on it or another similar label might of course be intended by parties to be a non-binding record of broad principles of an agreement yet to be made formal in written documents. or it may be a binding contract governing parties' relations until a more detailed agreement is drawn up. The two most helpful recent authorities on the use and the interpretation of heads of terms documents are Green Deal Marketing and Economy Energy Trading, and from 2019 in the High Court, and Mahmood and the Big Bus Company from 2021 also in the High Court. Green Deal Marketing involved an incomplete agreement that was subject to formal agreement within 90 days, but it was nonetheless held to be legally binding. The court found that the heads of terms took effect as a valid contract. They were intended to have legal effect, and sufficient matters were agreed for them to be capable of constituting a contract. And the parties had acted in that case on the basis that the heads of terms were governing that contract. So that's Green Deal Marketing. The second significant case on this is Mahmood and the Big Bus Company. This concerned a claim for negotiating damages by Mr. Mahmood, a Pakistani businessman, against the Big Bus Company, a well-known operator of double-decker tour buses. The claim was for a breach of a commitment given in a heads of term document when the parties were considering a joint venture bus tour operation in parts of Dubai. The commitment in the heads of terms was that the Big Bus would not circumvent Mr. Mahmood in Dubai. The relationship, as these things do, soured, and the parties did not go on to establish a tour bus operation in Dubai. However, Big Bus did go on to do so, and in doing so, they cut Mr. Mahmood out of the process. And in this case, the judge found that the heads of terms document was binding in the relevant part, and the Big Bus's continued involvement in the operation of the new venture in Dubai constituted a continuing breach of its commitment not to circumvent Mr. Mahmood. The judge also found that the anti-circumvention commitment in the heads of terms document was in substance a valuable asset. So in summary on this important and eighth and final principle, when it comes to subject to contract and heads of terms, neither are necessary to expressly negative contractual intention, and the authorities show that neither are absolutely conclusive. So that is the end of my outline of the key principles to be considered when assessing whether pre-contractual negotiations have become legally binding, or when legal practitioners need to consider the principles when they are seeking to avoid entering into legally binding agreements inadvertently at the pre-contractual stage.
So thank you to everyone for attending. It's been a very productive and informative webinar, I hope. So yeah, look forward to seeing you again soon.
Thank you.